If you're renting in the UK, chances are you've paid a tenancy deposit, often hundreds, sometimes thousands of pounds. But do you actually know what happens to that money once it leaves your account? Who holds it? What your landlord can legally deduct? Or what your rights are if they refuse to give it back? In this video, I'm breaking down exactly how tenancy deposits work in the UK. We'll cover the rules landlords must follow, how deposit protection schemes operate, and how to win disputes if things go wrong. Whether you're a first-time renter or dealing with a tricky landlord, this guide will help you protect your money and assert your rights. Let's get into it. What is a tenancy deposit? A tenancy deposit is a sum of money you pay at the start of your tenancy. It acts as security for unpaid rent, damage to the property, breach of the tenancy agreement. This isn't rent in advance, that's a separate payment and treated differently under UK law. The deposit is there to cover genuine losses the landlord might incur due to your tenancy, not to pad their profits. Most tenants pay the equivalent of 4 to 5 weeks' rent. And in England, there's a legal cap. Landlords cannot ask for more than 5 weeks' rent as a deposit, unless your annual rent exceeds £50,000, in which case the cap rises to 6 weeks. When must a deposit be protected? If you're renting under an assured short-hold tenancy, which applies to the vast majority of private renters in England and Wales, your landlord is legally required to protect your deposit in a government-approved scheme. This rule has been in place since April 6, 2007. It doesn't matter if someone else paid the deposit for you, like a parent or partner. If you paid it in installments. If you renewed your tenancy. As long as you're on an AST, deposit protection is mandatory. If you're not on an AST, for example, if you're a lodger living with your landlord, the rules may differ. But for most renters, protection is non-negotiable. The 3 government-approved schemes. In England and Wales, your landlord must use one of these 3 schemes. 1. Deposit Protection Service, DPS. 2. My Deposits. 3. Tenancy Deposit Scheme, TDS. These schemes operate in 2 ways. Custodial schemes, the scheme holds the deposit. Insurance-based schemes. The landlord holds the deposit, but it's insured against misuse. Either way, your money is protected. Your landlord cannot simply keep it in their personal bank account or stash it in a drawer. What your landlord must give you. Within 30 calendar days of receiving your deposit, your landlord must provide what's called prescribed information. This includes the amount of the deposit, the scheme used to protect it, how to get your deposit back, what deductions can be made, what to do if there's a dispute. This isn't optional. If your landlord fails to provide this information, you can take legal action, and they may be ordered to pay you between 1 and 3 times the deposit amount as compensation. That's right, if your deposit was £1,000, you could be awarded up to £3,000, plus the return of the original deposit. What can your deposit be used for? Your landlord can only deduct money from your deposit for specific reasons. Unpaid rent. Damage beyond fair wear and tear. Missing items from the inventory. Cleaning costs, but only if the property was left significantly dirty. Breach of tenancy agreement, e.g. smoking indoors when prohibited. They cannot deduct for normal wear and tear, like faded paint or worn carpets. Redecorating just because they want to. Professional cleaning unless the property was genuinely dirty. Minor scuffs or marks from everyday living. The deposit is not a slush fund. It's tightly regulated, and landlords must justify every deduction. How to check if your deposit is protected. If you're unsure whether your deposit was properly protected, you can check online using the tools provided by each scheme. You'll need your tenancy details, such as your postcode, tenancy start date, and deposit amount. If you search and nothing comes up, that's a red flag. It could mean your landlord failed to protect the deposit, and you may be entitled to compensation. Citizens Advice and gov.uk both confirm that deposit protection is mandatory under an AST, and they provide step-by-step guidance on how to check. What happens at the end of the tenancy? When your tenancy ends, here's what should happen. 1. You request your deposit back through the scheme. 2. The landlord has 10 days to respond. They either agree to return the full amount, propose deductions, dispute your claim. If both sides agree, the scheme releases the money. If not, the dispute goes to free adjudication. You don't need a solicitor. You don't need to go to court. The scheme handles it, and their decision is binding. How deposit disputes work. All three schemes offer a free, independent dispute resolution service. Here's how it works. You submit your evidence. The landlord submits theirs. An adjudicator reviews everything. They make a final decision. Evidence can include photos and videos, inventory reports, emails and messages, receipts, bank statements, tenancy agreement clauses. The key is proof. If the landlord can't prove damage or loss, they won't win. And if you can show the property was clean and undamaged, you're in a strong position. The importance of inventories. Inventories are absolutely crucial. A proper inventory includes photos of each room, descriptions of furniture and fixtures, meter readings, notes on condition. If there's no inventory at the start of the tenancy, the landlord will struggle to prove any damage at the end. And if they can't prove it, they can't deduct for it. No inventory equals tenants usually win disputes. What if your landlord didn't protect your deposit? If your landlord failed to protect your deposit, you can take legal action. The court can order them to return your original deposit, pay you 1 to 3 times the deposit amount as a penalty. You don't need a solicitor to start a claim. But legal advice can help if the case is complex. Special cases. Let's quickly cover a few exceptions. Scotland. Scotland uses its own system under the Tenancy Deposit Schemes, Scotland, Regulations 2011. The principles are similar, but the schemes are different. Northern Ireland. Northern Ireland also has its own rules and approved schemes. Deposit protection is mandatory. Lodgers. If you live with your landlord, deposit protection usually doesn't apply. Valuables instead of money. If your landlord accepts a car, watch, or other item instead of cash, it cannot be protected by a scheme. Always check your tenancy type and location to confirm your rights. How to make sure you get your deposit back. Here's your checklist. 1. Take clear photos on move-in day. 2. Keep copies of all communication. 3. Report repairs in writing. 4. Clean thoroughly before moving out. 5. Take photos on move-out day. 6. Return keys properly. 7. Request your deposit promptly. These steps help you build a strong case if there's a dispute. The more evidence you have, the better your chances. Final thoughts. Tenancy deposits can feel like a mystery, especially when landlords are vague or uncooperative. But the law is clear, and the protections are strong. If you know your rights, keep good records, and act quickly, you can avoid most problems and recover your money. If you found this breakdown helpful, hit the like button, it really helps the channel grow. And if you want more videos on UK renting, landlord disputes, or tenant rights, make sure you subscribe. Drop your questions in the comments, I read every one. Thanks for watching, and good luck with your tenancy.